name is Narissa Ferry and I am one of the medico-legal advisors at MDA National. As we move into another year of the COVID pandemic, it's a good opportunity for us to reflect on the challenges facing our doctor members and in particular our fantastic anaesthetists. As a member-owned organisation, it's really important for us to engage with you in a way that adds value to your practice. And while we would prefer to see you face-to-face, another year of COVID has sadly sent us back to our screens. But I am very pleased to be able to present a year in review on behalf of the entire professional services team. On the regulatory front, we've seen changes in the way that AHPRA conducts its investigations in an effort to deal with notifications in a more efficient manner. AHPRA will now call practitioners for a telephone discussion while a notification is in the triage or assessment stage. This is likely to be the very first time that you become aware of the notification. While the intention is to streamline the process for low-level matters, this step is voluntary and practitioners should remain cautious about the extent to which they provide a verbal response. We recommend you seek advice from MDA National before speaking to AHPRA, as file notes of these conversations will be retained and they can be relied upon as evidence in an investigation. We have also seen an increase in the number of practitioners being compelled to attend interviews under Schedule 5 of the national law. Schedule 5 interviews are requested for matters that are already under investigation, so it's not a power that AHPRA will use at the beginning of the notification process. The interviews can be lengthy and confronting for practitioners as they're often put on the spot and don't have an opportunity to seek legal advice before answering questions. The questions can be open-ended, which can lead to practitioners saying more than they need to and potentially making them vulnerable to further investigation. In the past, AHPRA rarely compelled interviews under Schedule 5, preferring practitioners to respond in writing, which allowed time to obtain considered legal advice and ensured that practitioners had a proper opportunity to consult their notes, reflect on their response, and undertake any education. Unfortunately, the legislation leaves little room for practitioners to be excused from attending these interviews, so we encourage you to seek advice from MDA before participating in a Schedule 5 interview. Other changes include the establishment of triage committees to assist in expediting matters before the board. Triage committees are delegates of the medical board and convene on a more regular basis than other delegates. AHPRA also has a dedicated COVID-19 team to respond to concerns relating to the pandemic. This team deals with notifications about practitioners issuing vaccination or mask exemptions against ATAGI and other government guidelines, doctors who are critical of the public health response to the pandemic, and other related complaints. This team tends to act quickly and will seek an explanation of any reported conduct or performance with the goal of ensuring that health practitioners are supporting public health efforts. The national boards have published guidelines regarding the expected role of registered health practitioners, and we encourage you to visit the AHPRA website for further information. According to the annual report for the Medical Board of Australia for 2021, 5,516 notifications were lodged with AHPRA, which represented 5.7% of the profession. The most common types of complaints related to clinical care, communication, and medication. No further action was taken in relation to 71% of notifications. Conditions were imposed in 6% of notifications, and 0.4% had their registration suspended, cancelled or surrendered. The Medico-legal team has noticed a gradual increase in the number of queries received via email, online notifications and live chat. Unsurprisingly, given the sensitive and often complex nature of medico-legal queries, phone is still by far the most common means of contact for our members, regardless of age or stage of career. In the past 12 months, we've received around 12,000 new notifications, with around 20% of those triggering the policy. Despite the pandemic, it's been largely business as usual in terms of queries, claims and investigations. If anything, COVID has just added an extra layer of complexity for everyone involved. We've seen COVID queries vary between the states and territories as public health orders and mandates have been amended and borders have gradually come down. In addition to providing personalised and tailored advice to individual members and practices, we have regularly updated our dedicated COVID webpage for ease of access. We certainly don't underestimate the additional pressure the pandemic has placed on doctors and their practice staff, both personally and professionally. Keep an eye out for our upcoming winter edition of Defence Update, which includes a feature pull-out on managing challenging patient interactions during COVID-19. Other common themes that we've seen on the medico-legal line include the perennial issues around privacy and confidentiality, the release of patient notes, family disputes, deceased estates, requests for medico-legal reports, employment queries, subpoenas to give evidence, and ending the doctor-patient relationship. The most common claims and investigations against anaesthetists relate to dental damage, preoperative and intraoperative management, informed financial consent, dissatisfaction with the procedure, and procedural complications. Some matters are more serious than others, and high-value claims often relate to poor neurological outcomes following intraoperative complications such as a failure to monitor the patient's blood pressure or administering the wrong drug, and pre-op failures relating to anticoagulation or poor history taking. We see more serious procedural complications occur during epidurals and arterial embolisation, and poor patient positioning can result in long-term nerve damage. The types of complaints that are directed to the hospital or to a regulatory body are often prompted by inadequate pain relief and anaesthetic awareness. We also know there is less tolerance for poor conduct in the workplace, particularly if that conduct impacts on other hospital staff. Behaviour that may have been acceptable 5 years ago is now under much greater scrutiny and could lead to a mandatory report or disciplinary action within the hospital. Check out our Risk Hotspots for Hospital Specialists webinar on our website, where we review common causes of medico-legal matters for anaesthetists and give practical tips related to their prevention and how to respond to an adverse event. Medico-legally, we have also seen a sharp rise in the number of notifiable data breaches arising from the theft of doctors' bags. Anaesthetists tend to be overrepresented in these cases because you often move between facilities and keep note of patient details for the purposes of billing and administration. Keeping patient information in a notebook can be risky, as personal information is incredibly valuable on the black market for its use in identity theft. There are safer options for storing patient data, and we can assist you to make some changes to your processes if you feel that your data may be at risk. Medico-legal advisory services work closely with the team from Support in Practice, who help members to avoid claims and complaints by providing advice about practice systems and processes. If you would like to speak to our Support in Practice team about some practical ways that you can protect patient privacy, then please contact us through the Medico-legal advisory line and we'll be happy to pass on your details. Our Education Services team also recommend watching the Privacy Q&A webinar recording, which is also available on the website. MDA staff answer members' frequently asked, overlooked and on-the-spot queries about patient privacy. This brings me to another area where Support in Practice has a lot of experience and expertise, and that is on the topic of informed consent. For there to be valid informed consent, the patient must have the legal capacity to consent, give their consent voluntarily for the specific treatment or procedure, have enough information about their condition, treatment options, the benefits and risks, and any alternative options. And this includes the opportunity to ask questions and discuss any concerns. If you'd like to have your consent forms or process reviewed, please let us know and we'll refer you to the friendly team in Support in Practice. Last but not least, I'll quickly mention informed financial consent. Complaints about out-of-pocket expenses can be time-consuming and frustrating for doctors. And again, anaesthetists tend to be overrepresented when it comes to complaints arising out of a miscommunication or misunderstanding about out-of-pocket expenses. To save you the time and effort of responding to these complaints, we recommend you review the AMA's resources and guides on informed financial consent. This brings our yearly wrap-up to a close. Thank you for the excellent work you have done over the course of the pandemic. If you need advice, support, or even just a sounding board, we're just a phone call away and we would love to hear from you. All the best for the remainder of the year, and thank you for trusting us to be your preferred medico-legal provider.